You are 19 years old. You are working a late shift, and you walk to your car in a dimly lit parking lot. You have a legal firearm in your waistband that you purchased to protect yourself. In Florida, for decades, that act alone would have been a felony, punishable by up to 5 years in prison. But today, depending on which judge you ask, that 19-year-old might be exercising a core constitutional right. The law in Florida hasn't just changed, it has fractured. And the reason goes far beyond a single statute. It goes to the very heart of how we interpret the Second Amendment. We are witnessing a seismic shift in real time. While most of the country is focused on national politics, the legal landscape for gun owners in the Sunshine State has been quietly rewritten by court rulings and strategic decisions by the state's top attorney. But here's the catch. It happened overnight, and it happened in a way that has created a legal paradox. One court says the ban on 18 to 20-year-olds carrying concealed weapons is unconstitutional. Another court, in the same state, looking at the exact same law, says it's perfectly fine. So, here is the question that every Floridian, and frankly, every American watching federalism in action, needs to answer. If the same law can be both constitutional and unconstitutional at the same time, do we actually have the rule of law, or do we just have the rule of whichever judge you happen to stand before? I want you to really think about that. Drop your thoughts in the comments below. Is this confusion just the growing pain of protecting rights, or is it a breakdown of the system? To understand how we got here, we have to look at a decision that sent shockwaves through the Florida legal system late last year. We are talking about a 1987 Florida statute that prohibited anyone between the ages of 18 and 21 from carrying a concealed firearm. For nearly 40 years, that was settled law. It survived legislative sessions, it survived public referendums, and it survived previous court challenges. But then, in October of 2025, Broward Circuit Judge Frank Leedy threw out a case against a teenager arrested for carrying a concealed handgun. Judge Leedy didn't just dismiss the charges on a technicality. He made a sweeping constitutional statement. He wrote, and I'm paraphrasing the core of his ruling, that because the plain text of the Second Amendment applies to the concealed carry of firearms, Florida's ban, as applied to 18 to 20-year-olds, is unconstitutional. Now, for those of you who follow the courts, you know that a single circuit judge's ruling usually applies just to that case. But what happened next is what flipped the switch overnight. Florida Attorney General James Uthmeier made a decision that effectively changed state policy. When the state sought to appeal a similar case where another judge had actually upheld the ban, Attorney General Uthmeier did something unusual. He told the appeals court that the state was wrong to prosecute the defendant in the first place. Think about the weight of that. The chief legal officer of the state of Florida stood before a court and said, "We concede that this law is likely unconstitutional." He refused to let the Broward State Attorney's Office defend the law, effectively pulling the rug out from under the very statute the legislature enacted. This wasn't the legislature repealing a law. This was the executive branch deciding that a law, as applied, could not be enforced against a specific class of people. And because Florida's appellate rules and the Attorney General's authority carry significant weight, his concession effectively signals to every prosecutor in the state that going after an 18-year-old for carrying a concealed weapon is on shaky ground. This is where the concept of law becomes incredibly fluid. The statute hasn't been struck down by the Florida Supreme Court. It remains on the books. But if the chief law enforcement officer refuses to defend it, and if trial courts are citing his position to dismiss cases, that law is, for all practical purposes, dead. Now, we have to step back and ask, what gave Judge Leedy and Attorney General Uthmeier the confidence to take this stance? It all goes back to the Supreme Court. For decades, the Second Amendment was a relatively quiet corner of the Constitution. But the Supreme Court's decision in District of Columbia versus Heller in 2008 changed everything. Then, in 2022, New York State Rifle and Pistol Association versus Bruin fundamentally altered the test that lower courts must use. Under Bruin, the old way of doing things, where judges would balance the government's interest in safety against the individual's right to bear arms, was thrown out. The new standard is text, history, and tradition. A court must now ask, does the text of the Second Amendment cover the conduct? If the answer is yes, the government bears the burden of proving that the restriction is consistent with the nation's historical tradition of firearm regulation. So, when Judge Ledee looked at that 1987 Florida law, he applied the Bruin test. He looked at the text. The Second Amendment speaks of the people. And the Supreme Court has consistently held, going back to cases like United States versus Verdugo or Quides, that the people refers to all members of the political community, not just a subset of adults over 21. If an 18-year-old is old enough to serve in the military, sign contracts, and be tried as an adult, how can they be excluded from the people for purposes of carrying a firearm? Then comes the history question. The state had to show a historical tradition of banning 18 to 20-year-olds from carrying arms in public in 1791 or 1868. And that's a heavy lift. While there were historical militia laws requiring specific ages for service, the government struggled to produce laws from the founding era that completely prohibited this specific age group from carrying common arms for self-defense. That historical analysis is the new legal battleground. It's no longer about whether the law is a good idea. It's about whether we did it in the 18th century. But the changes in Florida aren't just about age limits. Let's talk about the visual of self-defense. Open carry. For years, Florida was known as an open carry prohibition state. You could have a concealed weapon with a permit, but if that jacket flew open and the gun was visible, you could be in trouble. That changed dramatically last year when a state appeals court struck down the open carry ban, and Attorney General Uthmeier again stepped in, declaring that ruling applied statewide. Now Florida is a constitutional carry state in a very unique way. You don't need a permit to carry a concealed weapon, and now you are legally allowed to carry it openly. But, and this is where it gets tricky, that doesn't mean you can carry it everywhere. We have what are statutorily defined sensitive places. You still cannot carry into a courthouse, an airport past security, a college campus, or a legislative committee room. This creates a fascinating dynamic. The law has shifted from you can't to you can unless. But here is the legal landmine that most people miss: the conflict between state law and local ordinances. Florida has a very strong preemption statute. That means the power to regulate firearms belongs exclusively to the state legislature. Cities and counties cannot pass their own gun bans. However, there is a bill currently moving through the Florida House, HB 6217, that seeks to repeal parts of that preemption. If that bill were to pass, it would open the floodgates. You could theoretically have a situation where driving across a county line changes your legal status from a lawful carrier to a criminal. This is the patchwork problem that the Supreme Court has often warned against. The right to bear arms shouldn't change based on a municipal border. If HB 6017 gains traction, we are looking at a massive legal battle that will tie back to the Bruin historical analysis. Did the founding generation allow for such localized restrictions? The evidence suggests they did not. While Florida's state courts are expanding rights, the federal government is quietly shifting its own ground in a way that impacts millions of Floridians. This is the guns and medicine conflict. Under federal law, specifically 18 U.S.C. Par 922 G. 3, it is illegal for any person who is an unlawful user of or addicted to any controlled substance to possess a firearm or ammunition. For decades, the ATF interpreted this to mean that if you used marijuana, even in a state where it was legal for medical purposes, you were prohibited from owning a gun. But in January of 2026, the ATF dropped a bombshell. They issued an interim final rule redefining what constitutes an unlawful user. This wasn't a small tweak. The new rule emphasizes that the prohibition applies to a pattern of use rather than a single instance. It clarifies that unlawful use means using without a lawful prescription or in a manner substantially different from that prescribed by a licensed physician. Why is this significant? Because it opens the door for medical marijuana patients to argue they are not unlawful users if they are following state law and a doctor's orders. This is a direct response to lawsuits, including one filed by former Florida Agriculture Commissioner Nikki Fried, challenging the ban. The ATF even noted in its filing that this change was necessary to address the harm to constitutional rights caused by erroneously denying a person a firearm. Now, let's be perfectly clear about what this does and does not do. It does not legalize marijuana. It does not make it safe for a heavy recreational user to walk into a gun store and pass a background check. But it signals a massive shift in enforcement priorities. It introduces the concept of medical legitimacy into a federal regulatory scheme that previously had a zero-tolerance policy. However, we are still waiting on the Supreme Court. The court is considering a case, United States versus Himani, which directly challenges the federal ban on gun ownership for marijuana users. If the court applies the Bruin test to this statute, they will ask, is disarming medical marijuana users consistent with our historical tradition? That is a much harder question for the government to answer. There was no concept of state-licensed medical marijuana in 1791. So, do we compare it to laws disarming intoxicated persons, or those of unsound mind? The outcome of that case could either cement this new ATF rule or blow it up entirely. Now, we cannot talk about Florida gun law without addressing the elephant in the room, the Marjory Stoneman Douglas High School shooting in Parkland. That tragedy directly led to the raising of the rifle purchase age to 21. And that law, too, is under direct assault. House Majority Tyler Sirois has filed HB 133, which would lower the minimum age to purchase rifles and other long guns from 21 back down to 18. The legislature has passed similar bills before, but the Senate has blocked them. But this time, the legal pressure is immense. The NRA filed a lawsuit challenging the age restriction, and while lower courts upheld it, the case is now pending before the U.S. Supreme Court. Here is the legal tension. The Parkland shooter was 19. He legally purchased the rifle used in the massacre. The state's response was to raise the age. But under the Bruin framework, the state has to justify that age restriction with historical analog. Opponents of the law argue that 18 to 20-year-olds were part of the militia at the founding. They were expected to own and maintain their own arms. Therefore, a law that prohibits them from buying those arms is antithetical to the very purpose of the Second Amendment, to ensure a well-regulated militia. This is the most emotional and legally complex area. It pits the compelling interest in public safety, an interest highlighted by Broward State Attorney Harold Pryor, who reminded us that 17 people were murdered in his community, against a constitutional right that the Supreme Court says is not a second-class right. So, where does this leave the average person? It leaves them in a legal no-man's land. We have a situation in Florida where the legal standard for what a judge looks for has changed, but the actual statutes haven't caught up. You have the Attorney General telling the world he won't enforce certain laws, but local state attorneys, like Harold Pryor in Broward, saying they will continue to enforce them because they are still on the books. Let me paint a real-world scenario for you. You are a 20-year-old student in Florida. You have a firearm in your glove box for protection when you drive through a high-crime area. Under the Attorney General's stance, you are likely exercising a constitutional right. But if you are stopped by a sheriff who has decided to follow the black-letter law of the 1987 statute, you could be arrested and charged with a felony. This is called a chilling effect. It's the exact opposite of what the rule of law is supposed to provide. Law is supposed to give you notice, a clear line between legal and illegal. Right now, in Florida, that line has been smudged by conflicting judicial rulings and prosecutorial discretion. This is likely to force the Florida Supreme Court or the Federal 11th Circuit Court of Appeals to step in and issue a binding ruling that resolves the conflict. As we watch this legal drama unfold, there are 3 critical takeaways I want you to lock in. First, the Bruin decision is the engine driving everything. Whether it's age restrictions, open carry, or medical marijuana users, the question is no longer, is this law reasonable? But, is this law rooted in history? This has empowered gun rights advocates in ways we haven't seen in decades. Second, the separation of powers is messy. The Attorney General's decision not to defend a law shows the immense power of the executive branch. While many applaud this as protecting rights, it also raises serious questions about the balance of power. If one person can decide a law is dead by refusing to defend it, what happens to the legislature's role? This is a constitutional question that goes beyond guns. It's about who governs. And third, federal preemption is the next battleground. With bills like HB 6017 attempting to dismantle state preemption, and with federal ATF rules shifting under our feet, the fight is moving from, can we own guns, 2. Where can we own them, and under whose rules? Understanding whether your local city council has power over you, or if the State House holds that power exclusively, is vital. If you lose preemption, you lose uniformity. And without uniformity, your rights become a moving target. This is a pivotal moment for Florida and, frankly, for the nation. The legal framework governing our fundamental rights is being rewritten in real time, not just by legislators in Tallahassee, but by judges applying 18th century history to 21st century technology, and by executive officials deciding which laws to breathe life into and which to let wither. The confusion you feel is valid. The legal system is straining to adapt to a new constitutional test. But amidst this uncertainty, one thing is clear. The days of blanket prohibitions are over. The government must now meet the high bar of proving that its laws fit within our historical tradition. As we move forward, remember that this isn't just about politics. It's about whether the Constitution means what it says, and who gets the final say in interpreting it. For the 20-year-old in that parking lot, for the medical marijuana patient who wants to protect their home, and for the sheriff wondering which law to enforce, these aren't abstract concepts. They are the daily reality of living in a republic where the law is always a living conversation between our past and our present.